Up next, the Attorney-General Christian Porter on the eve of an all-media press freedom campaign which kicks off tonight. And ahead of that campaign, the chair of the ABC, Ita Buttrose, spoke at the Lowy Institute last night and took issue with the Attorney-General's recent decision to instruct the Commonwealth DPP to get his sign-off before prosecuting journalists.
We at the ABC would like to know if our two journalists are going to be prosecuted or not. And we think they've been under pressure long enough and it's time a decision was made.
Do the Attorney-General's assurances give you any comfort?
No, they didn't.
Why not?
Because I don't think one man should be responsible. You know, it has to be uniform across. We all need to know where we stand. It's not one bloke that should be deciding this. No, I'm not happy with that at all. And I don't think anybody else is either.
Attorney-General, welcome to Insiders.
Good to be here.
Well, she's got a point, hasn't she, about that sign-off? I mean, what if the journalist is investigating you or your office? It's not much of a reassurance, is it? It's not much of a safeguard.
Well, the Attorney-General has the ability to send a direction to the Commonwealth Director of Public Prosecutions and request that they seek the Attorney-General's consent. There are also a whole range of statutory offences where that consent has to be sought as a matter of statute. So this is a sort of long-standing part of the system. I might note that journalists, when previous legislation were going through, were calling very strongly for my consent to be required on a whole range of offences. So it's a slightly different position than that which was adopted by journalists not more than a year or 18 months ago. But I just simply did that because I thought that in all the circumstances on balance, that was an extra and appropriate safeguard in the context of the warrants that we know have been executed. But if I might just make one point about that, and that is that these warrants and the execution of them and the determination as to who may or may not charged and what the brief of evidence is always conducted at extreme arm's length from government by the AFP. And sometimes those investigations do take a while to run their course.
Yeah, but how long? I mean, how long can this go on? I mean, you, for a number of times since the raids, have said you're seriously disinclined to approve prosecution of journalists, except in the most exceptional circumstances. You've instructed the DPP, as we just discussed, to seek your consent before a prosecution proceeds. You couldn't be signalling more clearly, could you, that you're unlikely to sign off on a prosecution of these journalists? I mean, why? How long are the police going to keep investigating if they're not going to get a prosecution?
Well, I mean, if I could answer that question for you, that would indicate that there's a breakdown of the independence of the AFP, and I just can't answer that question. That can only be answered by the Commissioner, I presume, of the AFP, because
it's fair to say, though, isn't it, that you're signalling you will not sign off on a prosecution of these journalists? Well,
I've said I would be seriously disinclined to consent to the prosecution of a journalist where they'd done no more than pursue public interest journalism. Now, I can't, though, give anything more definitive than that, because my role in this process is to assess a brief that may or may not come up and a recommendation that may or may not come up from the Commonwealth Director of Public Prosecutions. And it wouldn't even get to that point until the AFP had concluded their investigation and delivered a brief, if they were minded, to the DPP for their consideration. So I can't abide by the law and give a definitive view without seeing what may be the evidence, if it ever reaches that point. But the fundamental point, I think, is that investigations, whether they be of any Australian, are conducted by the AFP completely arm's length from government, as it should be. But these are extra safeguards put in place in that process.
So the ABC and Nine later in the week urged you to explain, or demanded really, that you explain the status of these two cases. They say it's gone on for a long time. How long are these journalists going to live under this threat of jail? Are you troubled by the length of time this is taking?
Well, I can understand the frustrations, absolutely. But again, I'm not privy to all of the elements of the investigation, what it may or may not be uncovering. These are matters that are investigated by the AFP at arm's length from government. But can I just say generally, I mean, all of these must necessarily be balancing exercise. I mean, we have a great commitment to the freedom of the press. It's a bedrock cornerstone of our democracy, but it's always been a freedom and a policy value that's been balanced against other things, whether or not that is defamation or the protection of identity of witnesses or the ability to investigate criminal offences. I mean, there's always been a balancing exercise. And I think as a government, the reason why we commissioned the Intelligence and Security Committee to look into the issue of warrants that might affect journalists is because we should always be mindful about whether or not that balance is perfect and whether or not it can be improved.
Well, the media companies are clear, and this is what this campaign will be about, that the balance is not right, it's imperfect. The FOI laws are too clunky, too many documents are stamped top secret, they're demanding contestable warrants so that media has a say in that, more protections for whistleblowers. We've had a number of inquiries since these raids, but heard almost nothing from the government yet about what's going to happen, where you stand on these demands for change.
Well, I think many of those demands are sensible things that can be considered in the context of the Intelligence and Security Committee inquiry, and that's what is happening, and that is the best placed parliamentary body to consider those types of issues.
So but that's sensible changes, sensible demands?
Well, I think that they're sensible things to be considered, but equally there have been demands from the Right to Know coalition that journalists have a blanket exemption from all national security and secrecy laws, or that journalists have a blanket exemption from laws relating to warrants on metadata. And I'm not so sure that those demands aren't sort of on the outer edge of workability and credibility. So some of the demands, I think, are sensible things that are being considered in a sensible way by the right body. But look, some of the demands, I've got to say, are right at the outer edge of workability.
OK. Let's go to the religious discrimination laws, the draft law. You want it to come before the Parliament, the law before the end of the year. Religious organisations want more. They're calling for faith-based businesses to be able to hire and fire people if they don't adhere to the religious doctrines. Will you give them more? Will you expand the rights, not just of schools, but hospitals, aged care, other faith-based businesses?
Yeah, well, I guess this is another balancing process.
Sure is.
Big business have basically said that they don't want any kind of regulation or limit on their ability to tell staff what to do and say in their spare time. I think religion would like to expand those organisations that are exempt from the operation of this Act so that they could hire on the basis of faith, and at the moment that exemption goes to churches and religious charities and schools.
Just on that, you mentioned so that they could hire on the basis of faith. Would it also mean, for instance, a hospital could refuse to hire a gay nurse, or an aged care home could refuse a bed to an older gay person?
No, those would be matters that would be pursuant to the Sex Discrimination Act. This would be an issue as to whether or not a religious school, for instance, an Islamic school or a Jewish school or a Catholic school, could have a reserve ability to hire people of the same faith as that taught by the school and which parents have chosen for their children to be taught at the school. And I think most people think that's reasonable. Of course, where the outer edge of that might exist, questions do arise with respect to hospitals and aged care.
So you expand the rights?
Well, what we said was that we, in our draft, did not include hospital and aged care at first instance because we wanted to learn more about how those organisations actually operate. And we have learnt a great deal during the sort of consultations that I've conducted, and I think that there are going to have to be some refinements of the drafting in that area. But those exemptions, though, can't extend too far, clearly.
Rights groups, others, have a number of objections, but in the area that covers health professionals, do you accept there is nothing in this law that would prevent a health practitioner refusing to treat somebody, not just because they've got a conscientious objection to the type of treatment procedure, but because they disagree with the lifestyle, the sexuality or the gender identity on religious grounds?
No, I don't think that's right. I think, again, that sort of conflates the Sex Discrimination Act and this religious discrimination bill, which might become an act. All we have said is that in determining whether or not some rule might be indirectly discriminatory to someone of faith, there are considerations about conscientious objection to procedures based on faith. And of course,
but can I give you another example? If a person, because of their religious belief, has a conscientious objection about homosexuality, could a health professional, for instance, refuse to give somebody the PrEP pill for HIV?
Look, I don't think that would... First of all, there'd have to be a rule that compelled the medical professional. This is about whether or not that rule that might otherwise compel the medical professional is a discriminatory rule because of the person's religion. So I'd have to know what sort of rule it is that compels that sort of service to be delivered.
OK. On another matter, Minister, on Syria, the government's resisted bringing home the women and children in the refugee camp in Syria for domestic security concerns. There are 46 Australian children stuck in northern Syria because the government hasn't brought them home. Do you accept that Australia has a legal obligation to investigate these alleged terrorism crimes and a duty to protect Australian civilians who are affected by a non-international armed conflict?
Well, there's two issues. One's about what our legal obligation may be with respect to investigations. One might be what our obligations are to try and assist Australians overseas. The third issue is just what is capable of being achieved in now what is perhaps one of the most dangerous places that exists on the face of the planet. I mean, we obviously receive briefings about what is happening because of the Turkish move into Syria, and it is unbelievably dangerous.
Of course it is, but up until this point, that hasn't been the situation.
But the ultimate answer is that there's nothing we actually can do in Syria at the moment without placing Australian lives at enormous risk and peril, which is just something that we would not do.
Would your answer have been different 2 weeks ago, before these hostilities broke out?
Well, it was also...
Do you have a legal obligation?
It was an extremely dangerous place 3 weeks ago, and now it's an unbelievably dangerous place.
Do we not have laws and mechanisms in place in this country? If it was possible to bring these people out safely, do we not have the laws to detain, to monitor, to keep tabs on these women if they are brought home and ultimately charged? I'm thinking things like control orders, for instance, to keep track of them.
Well, all those regimes exist, but again, I circle back to the point that there isn't a practical capacity to do what you're suggesting should be done,
well,
which
I'm
is
saying
to
if
remove
it was
people
possible
from
to
the
get
zone.
them out,
but it's not. It's just not without putting Australian lives at enormous peril, and we are just not prepared to do that in the present circumstances.
Minister, on another issue, the federal government has been critical of the ACT's new laws legalising personal cannabis use. Are you going to use Commonwealth laws to strike out that ACT law or override that territory law?
Well, I think they're terrible laws for a variety of reasons. I've written to the ACT AG today, simply stating what is the best advice we've received about the legal situation that's been created. But that advice, which I wholeheartedly agree with, is that the Commonwealth law that criminalises possession of cannabis in amounts under 50 grams is still valid law in the ACT. The ACT laws removed the criminal component at a territory level, but didn't establish anything that is a positive right to possess, which means there's no defence to the Commonwealth law that criminalises amounts under 50 grams. So my advice, and the advice that I've provided to the ACT Attorney General, is it is still against the law of the Commonwealth to possess cannabis in the ACT.
If the ACT leaves its law as it is, will the federal government move to use the territory's power to override it?
Well, if they leave their law as it is, why would there be any need to override a law which is effectively to no effect?
OK, what if they translate it into a positive right?
Well, I mean, you know, what they do from here is up to them, and we'd consider the situation into the future. But at the moment, their law has not done what they think it does, which is provide some kind of defence or out for people who'd be possessing cannabis in the ACT. It doesn't do that. OK,
you've told them how to do it, though. If they change it, if they make it a positive right, would you then consider using the territory's law?
Well, again, what they do from here is up to them, and that is a strictly hypothetical question.
But you're not ruling it out, use of the territory's power?
Well, we'll just see what they do from here. But they've not achieved what it is, I think, that they set out to achieve legally.
Minister, on another issue, the ABC report into the slaughter of racehorses this week has provoked outrage and calls for government intervention. Some of the cruelest treatment of the animals we saw in that report happened in an abattoir which is licensed to slaughter horses for export meat, the international market. That export abattoir comes under Commonwealth jurisdiction. Is the federal government investigating how these practices were allowed to occur? As I understand it, under the law, Commonwealth-appointed vets are supposed to be overseeing the slaughter in these places. Well, yes. I mean, the footage is just beyond terrible. Obviously, animal welfare is essentially a state matter, and obviously we want to see fulsome investigations at a state level for the substantive animal welfare offences that may have been commissioned here. You're right. There is an oversight by the Commonwealth with respect to
organisations that need certification for export. One of these abattoirs is one of those organisations. It's probably something that the Agricultural Minister will have more to say during the week, but I understand at least one part of that footage demonstrates a potential breach of the standards that are required under the Commonwealth supervision, and I understand that's something that'll be looked into.
Have you seen it? Did you see the show?
I've seen excerpts of the footage. I must say I haven't got to see the full footage as of yet.
What was your reaction to it?
Well, I think it's astonishingly terrible behaviour, the excerpts that I saw.
Attorney General, thank you very much for joining us on Insiders.
Thank you.